And we are live. Welcome to the Atlanta Landlord Luncheon. We're so glad to have you guys joining us for lunch or whenever you're watching this presentation. So each month at the Atlanta Landlord Luncheon, we want to bring you market updates, investor news, networking events so that buy and hold real estate investors can build wealth long-term in real estate. So I'm joined here with Chris and Donna Littleton of PMI Georgia. And jumping on in just a minute, we got Chip Cagle and Monica Gilroy who will be joining the conversation. But starting off, I just wanted to introduce a little bit about what we do here at PMI Georgia. So we offer simple, straightforward property management with Southern hospitality. We manage over 500 doors throughout Metro Atlanta, most of which are single family and small multifamily homes. And if you are interested in a free rental analysis for your property, whether you're thinking about whether to sell or rent, or if you have an experienced portfolio that you're looking to grow, we'd love to offer you a free rental analysis and see how we might be able to help you. And I'm going to hand it over to Chip Cagle at Longhorn Investments. Chip, are you there?
I'm here. Hey, so I'm at Hobnob Tavern in Atlanta near Perimeter Mall, and we meet here live on for these events. We do get here about a half hour earlier than this is just starting. We get here at 11:30 a.m. and we network. We place our orders at the restaurant. Then we're here for the presentation, and after that we stay and network some more. So next time, come to the live event at Hobnob Tavern near Perimeter Mall. All right, Longhorn Investments. So I work for a hard money lender, Longhorn, out of Dallas, Texas, but I'm in Atlanta, and we do loans for fix and flips and also fix and holds. So on the fix and flip side, they're really the same thing. I'll explain the difference. On fix and flips, we can offer 100% of your costs, that's your purchase and your rehab budget, as long as that's less than 70% of the appraised ARV. Now we can go up to 75%, and that's where the hold part comes in. You got to get pre-approved for a rental refinance when you're finished with your rehab, and then we would be able to lend 75% of the after repair value. All right, that makes it a little bit better for you on a rental property. We can close as quick as 5 to 7 business days. You got to get the documents to us, and then they'll close about 5 days later. And I've been closing a lot of them within 5 days recently, so things are going smooth. One thing that I put together here, let's see, I'll try to get it a little closer, is a sample cash to close for a typical deal. So I got $200,000 as the purchase price, $50,000 as the rehab budget, and in this case, they're going to get 100% financing by getting that rental loan pre-approval, and they won't have a down payment, but they will have cash to close because there will be points and fees, closing costs, insurance. You would have already paid for the appraisal, and then lastly, there would be prepaid interest for the remainder of the current month. So in this case, all those totaled up to about $13,000. But that's going to be a whole lot better than a 10% down payment with another lender. So I'd love to talk to you about it. My phone number is 404-216-5599, or you can email me at ccagle@longhorninvestments.com. It's actually up on the screen. Thanks.
Awesome. Yeah, thanks, Chip. Next month, give me a PDF of that, and I can make sure it ends up on the slides.
Okay. And yeah, speaking of next month, for this year, it'll be the first time we're having our meeting on a day that's not a holiday, but it is St. Patrick's Day. We hope you
okay.
The luck of the Irish be with us.
That's right. Well, I know when it comes to talking with landlords and investors, they have a lot of questions about squatters, evictions, habitability concerns that are coming up. And so I know it can be very scary. And so that's why I'm really excited to have Monica Gilroy on with us today to talk about a legislative update for landlords here in Georgia. There's a lot of laws that were passed last year, and I guess they're in progress of being implemented this year. But I'm going to let Donna Littleton introduce our speaker today. So Donna is our managing broker here at PMI Georgia, and I'm going to hand it over to her.
Well, I am so excited to have Monica on with us today. She is just one of the best people that we know. Monica is the founding member and managing partner of the Gilroy law firm in Atlanta, Georgia. For over 33 years, Monica's national law practice has centered on real estate litigation and assisting property management companies, brokers, and owners with all aspects of their business. She is the general counsel of the Atlanta NARPM chapter, providing legal services to its members. As a subject matter expert, Monica works closely with property managers, lenders, and real estate companies in handling their litigation issues, including fair housing issues, and working to create protocols to prevent the same. Monica has been named the top 50 women attorneys in the state of Georgia. Monica is a national speaker and educator on property management, real estate, and related litigation topics. And it is really our pleasure to have her on our podcast today. Welcome, Monica Gilroy.
Thank you, Monica.
Thank you so much, Chris and Donna. And talk about people that are very special. These two are the best in the industry. They are just fantastic. So thank you so much to Donna, Chris, and Matt as well for letting me be here today. I'm excited to join you.
Awesome. Yeah, we'll go ahead and pull up the slides, but we'll let you lead the way.
Okay, very good. So everyone watching, again, Monica Gilroy. So, one of the things that Donna told you is that I'm a litigator. I'm a trial attorney. So very much when I'm here talking to you, I'm talking to you usually bringing a little bit of bad news about ways you can get into trouble or ways that you can have liability. So I'm trying to help you understand both the benefit of knowing and understanding our Georgia laws in this area, and knowing how important it is to be compliant with our Georgia law as landlords, because there's just so much liability that can arise. So what we're going to do this morning or this afternoon is we're going to talk about 3 pieces of legislation that were actually put into effect about 9 months ago for the most part, and sort of just refresh ourselves on those, and then talk about a little bit of how they're going, basically what we're seeing. So on your screen right there, these are the 3 pieces of Georgia legislation that went into effect, like I said, about 9 months ago. The first one was House Bill 1017, which was called the Georgia Squatter Reform Act. We'll talk in a minute about squatters and the terrible problem we have here, especially in Metro Atlanta, with people who are illegally trespassing into houses. And then there was House Bill 1203 about the service of the eviction writs, that for years we were handcuffed here in Georgia, only being able to use the sheriffs in their counties. And this law basically allowed us to go and utilize properly trained, what are called peace officers, non-sheriffs or off-duty sheriffs, so to speak. But unfortunately, the implementation of this wonderful benefit we were given has been running into a lot of roadblocks, because the counties are kind of irritated that we're taking away some of their revenue by using third parties. So we're going to talk a little bit about how it's supposed to work and what we're seeing. And then sort of anticlimactically, the last bill that was passed was House Bill 404. It's called the Safe at Home Act. And we were all up in arms as an industry about this bill, because this is the bill that requires the 3-day in-person posting of your eviction notice on your tenant's door. And as an industry, we were just like losing our minds, like, oh, that's so dangerous. That's just not going to work. And it's actually not been as bad as we thought. So why don't we see what the next slide says, Matt? It may just bring us right to the Squatter Reform Act. Yeah. So let's just keep it on this slide for a second. So let's start first with the Georgia Squatter Reform Act. Okay, it's effective right now, and it created, friends, a new crime called unlawful squatting. Now, I often get asked, what is a squatter? Is there a difference between a squatter and a trespasser? And the answer is, there is none. Okay. In fact, I think squatting actually sounds too nice. These are individuals who have broken in under our law to pieces of property and have taken possession of it illegally and unlawfully. Do you want me to keep going, Matt?
Yes, please.
Okay. So the law, basically it's going to say that you're committing the offense of unlawful squatting when you enter upon the land or the premises of another and reside in that land knowing that you're not supposed to be there, that you don't have any authorization to be there. And resides means inhabiting. So let's hold on this slide for a minute and just kind of talk through the real logistics of this, right? Let's say your piece of rental property is in the turnover process. It's empty for even just a few days or a week. These are individuals who are literally breaking into these pieces of property. They are, using elbows to go in through the back glass pane window, reaching in, unlocking the door. These are people just literally legitimately getting into the properties, knowing they're not supposed to be there, and then refusing to leave. So it's a very serious situation when we think about the fact that this causes terrible problems with our revenue. How do we get these people out, etc.? Let's go to the next slide, please, Matt.
All right.
Okay, thanks. Okay, so this is how the law is written, okay? That the squatter is first accused of squatting, okay? So what you would do is you would find out, someone has, again, illegally trespassed, broken into my house, and you call, right, your sheriff or your city police department. Now, it depends on where you are within the state of Georgia. Here in Metro, right, if you were in the city of Atlanta, don't call the city of Atlanta police. They're not going to do anything. It's Fulton County. Usually we're finding in Metro, it's the counties who are responding. Now, my advice that I've given to everyone that has dealt with this issue is not to say, I'm calling to report a squatter. I say, I am calling to report an illegal trespasser into my home. And you need to think about this no different than if I went over to Chris and Donna's house, broke the back window and came in, right? I'm not authorized to be there, right? So when we say those words trespasser, we hope to get a little bit more urgency from our law enforcement friends, right? So you call up and you say, I need to report a trespasser, a squatter. The officer then comes out. If the squatter is there, which hopefully they are, the officer is supposed to talk to the squatter and basically say, show me proof that you are supposed to be here. Okay. So in theory, they could pull out some piece of paper, if it's a fake lease or a fake document and say, well, oh no, I'm supposed to be here, right? This is legal for me to be here. If they cannot pull out a piece of paper, they are supposed to be literally under the new law, packed up and put out that right at that minute, right? You don't have to wait for anything. Nothing. That's the way the law reads. Okay. Now, the practical application we've been seeing is a little different, right? Depends on sort of who answers this call. Some of the law enforcement are helping us with that. They're saying, look, I'm going to give you 24 hours to get out and come back. And if not, you're arrested. Some actually do sit there. But what we're finding, unfortunately, is that even without a piece of paper to show, the police sometimes are just saying, well, I don't know how to, or the law enforcement sheriffs are saying, well, I'm not sure about this. I'm not, you may need to file an eviction, property manager or owner landlord. And so this is why it's so important to really understand your rights, right? To be able to say, no, you need to do something about this right now. I don't have to file for an eviction. Now, if for some reason the person who's illegally squatting in the home produces a piece of paper, and usually we like to suggest that someone from the landlord is there. So the landlord can say, no, this is not a legitimate lease or piece of paper. The court then basically cites and commands the squatter, like it says on the screen, to come to the head of what they call the issuing law enforcement agency. So in this case, if it's the sheriff that's coming to make the addressing your call, the illegal squatter trespasser is supposed to go to the sheriff's office with something that proves that they're supposed to be there and proves that it's legitimate. If they do not do that, right, then again, they're automatically thrown out. If they do that, if they do show something, right, then it's supposed to get tossed, right? The whole situation is supposed to get tossed to the top of the magistrate court's docket, the list of cases, so that it's heard right then and there within a matter of, a week by a court as to whether or not this person is allowed to sit there or not. Now, I will share with you, Fulton County was doing great here in Metro Atlanta. They actually created a squatters court, and they actually put in charge of that court a really excellent judge who knows evictions, knows our world, knows the world of the landlords and tenants, and they even had a separate clerk, and things were working well. But suddenly they got too backlogged. So now we're finding that where we were able to get in, be heard in front of a judge within maybe 10 days, which is miraculous, right? To have actually have someone hear us in that amount of time, it's backing up a little bit. Now, one of the things that's interesting about this squatter court, so let's say you find yourself there, the person, you've called the police, they're saying to the police, no, I think I have a right to be there. The police say, fine, I'm gonna throw this to the court. The court is actually conducting a criminal hearing. It's not like an eviction. It's actually a criminal hearing, because remember, this whole new law created a new crime of squatting. So the court is looking at it from a criminal perspective. So the landlord, right, is the victim, right? You're the victim. And the police, the responding officer, they're like the state of Georgia, right? So it's you as the landlord are sort of taking more of a backseat. But what I've found is that if you go in and are able to articulate the law and what you're doing, you're going to end up sort of taking control of the hearing. But the judge is determining whether or not that tenant is, under the penalties that are assessed, going to jail, obviously getting tossed out, but also being fined or not. Go forward a couple more slides, Matt. I think there's one that talks about let's go.
Okay. Yeah. And I did want to mention.
Sure. Yeah, stop right there. That's good. Go ahead.
I did want to mention, one thing I think a lot of people don't understand. I think most people understand the idea of a squatter, somebody just breaking into the home, attempting to live there, even as brazen as changing locks, setting up utilities, all those kind of things, right? But
Yes.
another thing that really ends up muddying the waters is people who are actually just victims of rental scams. So
Yes.
the criminal will download photos from a current listing. They will put it on Facebook Marketplace and advertise it as if it's their own. They create a fake lease. They take money from whoever thinks they're actually renting it. And then they move into the home, unbeknownst to them, that it wasn't a valid lease. So if you could speak a little bit to that.
Yeah, that's situation. That's the flip side. That's exactly right. That oftentimes then we find ourselves in court, or we find the sheriff talking to someone you're exactly right, Matt, a victim themselves. But unfortunately, this law would still apply, right? They're not given, just because they have been, defrauded or taken advantage of. The law is still saying that they're not allowed to be there if there's not a valid legal document. Now, it's in terms of like prevention, it's a tough thing, right? I mean, it's why the property managers are there to, really work hard to protect. They're obviously, equipping themselves with tips and tricks to take care of this. An average landlord trying to kind of do it on their own, it can get a little tricky. We sometimes recommend, having someone actually monitoring the property via Ring cameras, or installing maybe like fake cameras to deter people. One client told me they actually put in their properties little placards that say, this house is professionally managed by management company. If you are here, if you have not spoken to anyone at this company, you are here illegally, right? So, as landlords, it can really be a challenge. But yes, those people under this law, Matt, and that's a great question, are still, although victims themselves, are still treated as squatters. Now, the practical application of that, though, is usually once we get talking with them in a court setting, they don't want to be, as it says on the screen here, they don't want to be found guilty of a misdemeanor, $1,000 fine. It actually has a jail sentence. So they're usually quick to cut a deal and say, no, we'll move out. We're going to leave. Now, I will say I was in court probably about 4 or 5 months ago before the new year. And the case ahead of me, the judge literally, the squatter, it was a true squatter, fighting, saying the lease was true. And the court literally arrested that person right there, found them guilty of violating the crime, or violating the crime, the statute, and literally said to the sheriff, take them off. So some counties are doing this very well. Some sheriff's departments, to Matt's point, are also, Matt and Donna and Chris, still not fully understanding it, where, especially when they're dealing with the victims, they're not sure what to do.
Yeah, often what we see with these, we've dealt with a few of these squatters too, is they can't provide proof of payment, or they can't provide the money trail in which the funds to secure the lease was available. So that's probably one of the first things you should be looking at if you're faced with one of these facts. Well, who did you pay the money for? What's their contact information? And that person should be here in court with you today. If he's not here in court today with you, then this is more than likely going to be the case where you're dealing with a true squatter or an intruder. So
Yeah, that's a great point, Chris. Because again, think about it, friends. If it's someone legitimate, there shouldn't be an issue, right? They should be able to say, "Oh," but yeah, that's a great point. That's a great point. So, I think my advice always is on any squatters, be calling the authorities a lot. If they come out once and you don't like the result, call again. But cite to the fact that we now have in Georgia this crime of illegal squatting, and then it's just what it sounds like. Someone has illegally come into a piece of property and they're not supposed to be there. So that was our first one, Matt. If
Yeah,
you want to
awesome.
flip, yep. Let's go to our second one. You may have to go through some slides there.
Go back to the.
Yep. No. You can go forward if you want.
Okay,
I think there's a
bill.
slide on the service of writs. Yep. There you go.
Yeah.
Right there. Perfect. So yes. So the second law that was passed is a really good one. Okay. And as you see on the screen there, it authorizes landlords to use certain off-duty, and there's this big long list of people: sheriffs, sheriff deputies, constables, marshals, or, and look at this one, other individuals certified by the Georgia Peace Officer Standards and Training Council. What the heck is that? That actually could be any of us, right? It's a training that you get, like it's what forest rangers get here in Georgia. Someone told me lifeguards sometimes get these, but the concept is you're trained and you have a certificate in being able to, keep the peace, so to speak. So rather than just limiting, when we've gone all the way through our long eviction process, we finally get our court date, we win, we ask for our writ of possession, and then we're told by the sheriff, "Oh, sorry, Miss Gilroy, it's going to be 4 more months before we can get out there," right? So to combat that problem, this law was passed, okay, allowing all these other people to basically serve a writ of possession. Now, sounds wonderful, right? For the first probably 2 months, my office, and I'm sure other lawyers who handle evictions and work in the landlord tenant community for landlords, we were trying to educate the law enforcement, the sheriff's departments, right? We were trying to say, "Hey, now, we have the writ and we're not going to use you. We're going to use somebody else," right? Only to be met in certain counties with a lot of red tape. Fulton County for a while I had to actually get in the car, drive down to Fulton County, go into the marshal's office, and was asked to present all this information. And so me being me, I said, very respectfully, why am I being asked to show my identification and my license for the state bar? And I don't understand. I'm not doing this. Only to realize as I continued to talk to the Fulton County Marshal's office, they were mad. They did not like that other people could get the revenue to serve the writs, to be there to exercise and serve the writs of possession. And we're making it extremely difficult to allow us to go forward in that process. They were actually in some counties being very threatening towards their off-duty sheriffs and off-duty sheriff's deputies, saying to them, if you are going to try to moonlight or go out on your own to be hired privately to serve these writs of possession, you can't do that. You're not allowed, which of course, without us even needing to be like labor and employment lawyers, we know that's not right. What you do in your off time shouldn't matter at all. What you do when you're not on duty. Now, so we still have in some counties in Metro Atlanta, sheriff's departments who literally will say, nope, you cannot use an off-duty person. They think that the way the statute reads, they're still in charge. I think it is obvious from the way the law was written that we're not supposed to have to use the sheriff at all, right? Because that's the whole idea. We need to be able to circumvent these offices that are so busy and that have not had time to, do what they need to do. So what we're seeing is in the counties that are allowing us to, very good. Yeah. And that's a good slide actually, because this is the only requirement, okay? That if the sheriff, right, the second paragraph there, friends, if they're unable to execute the writ within 14 days. So you get your writ on January or February 1st, right? And they say, oh, I'm sorry, we can't do the set out until May 5th, right? That's all you need. Now, you don't have to wait 14 days. You can literally get your process set up to have an individual serve it on the very day they tell you, right? On February 1st, oh, I'm sorry, it's not going to be till May. Okay. And then what you have to do is literally just there are services that have popped up across Metro Atlanta who are offering just this. They're offering to serve as your off-duty officers to do your eviction, your writ execution, your setouts, right? They are charging about $500 an officer, usually with a 2-officer minimum. So it's looking about $1,000, okay? But in my experience, I've been able to call these third-party providers on a Monday and have something scheduled for a Friday. Let's say that again. $1,000, right? To get somebody out there 5 days after I've gotten my writ. So it may not be for every single situation, right? But
Monica,
yes,
we've had this situation in our office. It was taking anywhere from 6 to 8 months in Fulton County. So we took advantage of this, and it worked rather well for us. But we were paying $600 an officer. That's an extra $1,200 expense. But when you consider you may be months down the road, it just makes sense to move forward with this, and it served us well. So
yeah. And don't you, Chris and Donna, was it in circumstances where like you had people in there for a really long time prior to putting them out?
yes, and in Fulton County, the judges were actually, you were going to court, you're getting your writs, but the judges were refusing to sign the writs, so that the sheriff couldn't enforce the writs until the judge signed off on it. The judges were actually holding back on the writs themselves, on executing the writs, because they had such a large backlog, and so they were doing some stuff that really didn't follow the traditional way they used to manage these. Because usually it used to be you could get someone out in about 45 days from the day they
Yes.
stopped paying.
Yeah.
Now we're 6 months. Even had some that I've heard horror stories of people going over a year not being able to take possession of their property.
Yeah.
That's
I
major
completely.
loss for an
Yeah,
investor.
it's terrible. And Chris and Donna, that's a really, that's exactly the point, is that while that may seem like, oh no, it's $1,200 extra dollars for an owner who has been without rent potentially for, months and months, or can't collect on a judgment, getting them out is great. So the law has been working it's a great law, number one. Number two, it's been working pretty well, but again, not unlike our Squatter Reform Act. You just have to advocate for yourself when you're dealing with the counties. If you're getting any pushback, you need to be able to say, look, you can't, sheriff's office, in whatever county, say we can't do this. We're allowed to do it. I'm thinking we might see a little bit of tweaking down the road to this law, where it's made very clear that you do not need the permission of the sheriff's office to use these individuals, because that's been kind of the only bumpy thing we've been seeing. But that's good to hear, Chris and Donna, that you've used them. And do you agree that there's been, from what I'm told, there's a number of these companies opening back up, that it's not, or opening up to help us? It's not like it's just one or two folks. We have
a lot of these are off-duty police officers, and even state patrols. They love the ability to make that extra cash. I mean, some people said that the pricing can be absorbent. It's a little high, but you know what? It's well worth it when you're sitting around for 6 months trying to get a tenant out, to push forward with the extra expense. And they're very professional. The ones that we've used were very professional as well, and they've actually helped us, on a couple of different cases to get them out as quickly as possible. So you make those relationships, and they will work well for you.
It's great.
Absolutely. And Cobb, is it true that Cobb requires 3 off-duty officers?
I think the Cobb is the one that, regardless of the size, requires 3. Yeah. And that, again, it's sort of just the price you have to pay. If it's a little small house, you hate to think of 3 people, but again, it's that spending money to save money,
Right.
And they do require a number of people per the size of the house too. Usually you're going to
Yeah.
have at least a crew of at least 6 and maybe more depending on the size of the house. So
Yeah.
they're expecting you to be have everything out of the house within 2 hours in
Yeah.
most cases.
Yeah. Yeah. So again, money well spent if you've been without income for so long in these houses. So that was a really good addition to our laws there. So let's stop at this last one here. So this one's important because this is the bill again that it's called the Safe at Home Act. And sometimes laws get passed and we don't really realize it as an industry, as landlords and realtors and property managers. Sometimes we just don't realize it, right? And when we do realize it, we're like, wait a minute. So this one, when it was being discussed at the Gold Dome, did have some additions to it that made sense, right? Like it was very tenant friendly. Okay. It made some things law that I think everybody probably knows, who manages property, or who owns property to have tenants in, things like that habitability, right? The concept that property in Georgia has to be habitable for a tenant to reside. And while Georgia does not have tons of laws that govern landlords, because we are a very landlord friendly state, I know it may not feel like it, but we are. Habitability is something that a landlord can't waive, right? It can't waive its ability to provide a habitable or livable environment for a tenant. Okay, Monica, what's habitability, right? Habitability is sort of like you know it if you saw it. I like to say, think of if you had your 85-year-old mother living in a home, where would you, in a rental property, what would you want her to have, right? She'd have to have running water, right? She'd have to have heat in the winter and cool in the summer. She'd have to have plumbing, right? She had to have the property free of mold or rodents, right? So habitability is the one thing that as landlords, we have to be sure we are always promoting within a property. So this law, in the beginning of it, in the first part of it, does talk about some things that are now absolutely considered habitability in Georgia, including air conditioning in the summer. Okay. So, if we have a situation and our air conditioner breaks on July 4 and it's an incredibly hot day, our job as landlords, right, under this, refined law is to just be sure that we're taking steps to ensure that it's habitable. Does that mean bringing in standing fans or units for the windows? Maybe. Does it mean putting them up overnight somewhere else? Maybe. Again, habitability is how you choose as a landlord to react, right, to the situation, but it is something that cannot be waived. It cannot be something you can't have a tenant sign a piece of paper that says, oh, if there's no air conditioning in July, you can't bug me about it, right? It doesn't work that way. So it talks about that. But keep going for 1 second. Yeah, there's habitability right there. Yeah, it basically says that premises are habitable. Go one more, Matt, please. Right there. It broadens the definitions of utilities, right? To be sure that habitability includes cooling, heat, light, and water. Okay, that's the first part of what it did. The second part that this law did is the part there on the bottom. It made it the Georgia law that you cannot accept a security deposit that exceeds 2 months' rent. So if you are currently holding 3 months' rent as a security deposit, that is against the law, and you need to give back one of those months. Okay. So going forward, if you're taking a security deposit, it cannot exceed more than 2 months of rent. Go forward to the next slide, please, Matt. Let's go forward to the next one as well. Okay. This is the third part of the law that caused us to be very concerned. It says the demand for possession. So they've fallen into default. The demand for possession, the notice to quit, whatever you want to call it, has to be posted in a sealed envelope on the door of the property in a conspicuous spot. What does conspicuous means? It means basically able to be seen, right? And of course, you still have to deliver it in any other method of set out in the lease. Now, we all thought, we were up in arms about this. We were like, oh my gosh, this is, first of all, it's so dangerous. I can't send my agent out to do this. This will be awful. But, Chris and Donna, tell me what you think, but it's kind of ended up being not a big deal.
I
Right?
tell you what, we developed a process for this. We go out there and we post these, and it's actually, some people think may help the tenants, but it's actually, you're, as a landlord, you're able to charge them a fee for this, just like you can delivering any legal document. So
Yeah.
it covers our cost, and and it's also, I think it's brought up retention a little bit. It makes them pay attention to when their rent is due, and we're getting more on-time payments, as for sure, out of this whole process. So it has had some benefits, but it is an extra additional cost. But it can be offset by your a fee to the tenant as well. So
Yeah. And the safety issues have not been there for
well,
the most
I
part.
look at the safety issues as like, well, I generally don't want to move in somebody into one of my properties I don't feel safe. I have to go visit. So we do
Yeah.
the screening process for us eliminates a lot of that risk.
Yeah, I agree. And there are lots of companies offering it. I have some that I know charge as low as like $50 or $60 a door. And to Chris's point, that's just a charge you would put back onto the tenant. And it actually has been in a court setting. It's actually been kind of easier for the courts to understand, because if a tenant came in and said, well, I didn't get any notice, these posting services are actually producing pictures, right, of the letter being posted in the envelope conspicuously on the door. And I had a couple situations in court where I was able to pull that out, and it actually, the judge, then looked at the tenant and said, no, you knew this was going on. So I'm glad to hear that it's working for you all as well, Chris and Donna.
Yeah, we use an inspection process that we timestamp the pictures in front of the property, but also it gives you a chance to get out and see how your tenants are actually taking care of their properties as well. So there are some advantages, because when they stop paying, sometimes they let things go, and so that sends up a big red flag. You go out there and the property's not being taken care of. So it helps us manage our inventory as well. So
Absolutely. So those are the three state laws that I wanted to mention. And then I know Chris and Donna, we had the opportunity to hang out together actually on the national stage in Washington, D.C. And so, I'll let Chris speak to that, but there are a lot of issues nationally that are going on for landlords as well.
Yes, one was it was a leftover from the
CARES Act.
the CARES Act, where they didn't sunset the 30-day notice. When we're working on actually, I think the Georgia state legislation is working on sunsetting that as well. But across the nation, they've had issues with that. So you can't even begin to file on someone until after 30 days. And so they're putting that to rest. Also, there's been a whole bunch of legislation, issues coming up with lead-based paint. And if you have a house that's older than 1978, 1978, you need to have these disclosures. If you send contractors out there, you need to make sure that they are their RP&P, the lead-based paint repair paint, they're certified to test for this and make sure that they're not disturbing lead-based paint. And what I would say about that is the fines are incredible from the EPA. And the EPA, that's how they get paid. They fund their operations off their fines. So when they start looking for these cases, they'll come in and they can really destroy you as an owner, or you as a property management business. So hopefully we'll get some relief from that as well. And
yeah, Monica, I know that you and Chris and Donna were recently in Washington, D.C. for the NARPM Day on the Hill. And so I'd love for y'all to share a little bit about what y'all learned and upcoming legislation that may be affecting us nationally and also here in our state.
Chris said it perfectly. And Donna, I'll give everyone the name of the bill that Chris was referencing. We actually have a bill that's currently been introduced. It was actually introduced by Representative Barry Loudermilk of Marietta. And it's called the Respect State Housing Laws Act. Big long word there. Respect State Housing Laws Act. And that's the one that sunsets, Chris is right, that 30-day requirement for the CARES Act for certain properties. And it was just something that they just forgot to put into the law after COVID. But we had a great time, didn't we, guys?
We did, and it really made me realize, you have to pay attention and point out to there's these big bills, and a lot of times our senators and congressmen don't realize some of the unexpected consequences of some of the things that are in there, or unintentional consequences, I guess. And so because we're in the field every day working, with the,
The
working the
law,
business,
business.
that they don't realize some of the things that can happen. So it's up to us to inform them of what's going on. And so it was so important to go in and explain some of these things that they didn't even know maybe was in there. And so I don't know, it was very enlightening to me to go to Washington, D.C. and see how things work, and see how there's these aides running around everywhere right out of college and taking notes, and how the process works. And it was just really great to get involved and listen to the people who've been there as long, going every year, like listening to Monica, who really knows her stuff, and made me really just want to get more involved. But you really have to pay attention to these bills that are being passed, because if you don't, you could be violating laws that you didn't even know were there. So it's really important that you're involved in these organizations like NARPM and pay attention to your great attorneys like Monica and keep up with things. So,
Well, Monica, I'd have to say, what I've seen, there seems to be a trend to moving toward trying to take some of your property rights away from you as individual owners. And we're seeing that a lot on the legislation that's coming around about short-term rentals, rental properties. The potential for the mom and pop investor to get to lose their rights is getting higher. So I've often said this: if you're not at the table with your elected officials, generally you're going to be on the menu. So you want to make sure that you get out there, you speak out about these issues that are going to cost you more money in business, going to cost you more taxes, whatever it is. Whenever they start doing these restrictive things on landlords, it's going to hurt everyone. And in most cases, the unintentional consequences is they're actually hurting the tenants as well, because if it costs a landlord something, it's going to cost a tenant something as well. So
yeah, they're exactly right. And just probably my final thought is, it is so important, as both Don and Chris said, to advocate for ourselves. There's always tales of woe about the tenants, right? But what people don't understand is that landlords, owners, are so negatively affected by these, laws that are so tenant protective. I always try to look at some of the clients that I have who perhaps, have owners who, I had one case where their owners were retired postal service workers, and all their money, their investment money, right, was tied up in these rental houses, who were plagued with slow courts and squatters. And they were in danger of even being further penalized through nothing they did themselves by some of these laws. So I agree. You are on the menu as a landlord and a property owner. And also, just because we've had a change in administration, don't naturally assume that we're all okay. There's still a lot of stuff floating out there that is not good. And we saw that when we were up on the Hill. But yeah, I agree. Even if you're not necessarily going up and joining us in DC, which is super. It is really fun and empowering as a person to do that. Just keep your eye on it, as Donna and Chris were saying. Just watch what's coming out of Washington, and watch what's coming out from under the Gold Dome, because you have a voice. You are your voice. You have the rights, and you should advance your rights to call your local representative or your federal representatives and tell them how you feel. They want to hear from you. As Chris and Donna said, they need to know what we're doing. They need to be educated by us, because we're the experts and we know what we do best. So yeah, it was great. So I'm really happy to have been here today, you all. Thank you so much for this opportunity.
Yeah, Monica, thank you so much. And we'll have to have you on more, because this was very informative. And I think there's a lot of landlords who are just not aware of the recent legislative changes. But the market in Atlanta has changed a lot too. I mean, we rank the highest out of all the metro cities for leasing fraud. And so there are a lot of adverse conditions that we face as landlords and property managers. And so we really appreciate the work that you do. And could you please tell people how they can get in touch with you if they have an issue with a squatter or evictions, or any other ways that you might advise them?
Yeah, absolutely. So my firm, as you see on the screen, is the Gilroy firm. We have a very robust website. So if you go in there and click under practice areas and hit the property management landing page, there is tons of great information there. There's forms, there's educational content, there's all sorts of things. And that will also, my website, the gilroyfirm.com, will also direct you best how to contact me. Always happy to be, oh yeah, and there you go too. Always happy to be of service. But I do encourage you to go and visit the website, even if you're not having a problem, because again, that property management page has just tons of great information, content, and things that could be of use to anyone who's either managing or owning property here in Georgia.
All right. Well, thank you so much. Chip,
You're welcome.
any final words?
No, looks like I'm muted though. Oh, now it's unmuted. All right. Hey, no final words, but just next month, come to Hobnob to join us live.
All right. And Chip and I do attend a lot of Atlanta real estate investor events. So if you're interested in checking out events, please reach out to us. We'd love to connect and see you at the next event we go to. Chris and Donna, any final parting words?
Just remember, real estate investing is a marathon, not a sprint. It'll make you wealthy over the years. So thanks, everybody.
That's right.
Thank you, Monica.
You're welcome. Thank you, guys.
All
Have a
right.
great day,
Thank you,
everybody.
everyone. All right. Bye-bye.
Bye-bye.
Bye.